This video is not legal advice. It is for educational purposes only. It does not create an attorney-client relationship. Always consult a qualified attorney for advice specific to your situation. Law is the normative life of a society. More precisely, it consists of society's enforceable rules that govern relations among individuals and between individuals and society itself. These rules define what conduct is permitted, what sanctions follow prohibited conduct, and how people can obtain compensation for wrongs committed against them. The law, therefore, anticipates private disputes. It anticipates that people may injure one another by breaching contracts, by trespassing, or by causing accidents. But if the parties cannot settle amicably, the law forbids self-help. Individuals cannot assault an alleged wrongdoer or seize property by force. Instead, the law permits only two acceptable means of resolving private disputes. The parties may settle matters themselves, with or without a mediator. Or, rather than achieving compromise or mutual satisfaction, the government may decide disputes by enforcing legal rights and duties. The government does this through judges or juries in civil litigation. Civil litigation is the established process for authoritatively resolving personal injury, contract, or property disputes. It is a public and structured method of conflict resolution within the court system, involving formal court filings and hearings, in which one or more parties seek to enforce private rights or obtain redress for private wrongs. That said, civil litigation ordinarily begins outside the court system, when an injured party consults an attorney or a law library to determine what rights were violated and how they can be enforced. The injured party also determines whether the legally prescribed period for initiating litigation has elapsed, which could prohibit civil litigation between the parties. Given these preliminaries, civil litigation is commenced in either federal or state courts. Federal courts, created by the U.S. Constitution and Congress, primarily handle disputes involving federal law or the Constitution. Each state maintains its own parallel judicial system to resolve disputes arising under state law. In California, the state courts adjudicate most civil litigation involving California parties and California law. The parties to civil litigation are called litigants. The party who initiates the litigation is the plaintiff. The responding party is the defendant. Although litigants are usually represented by attorneys, they may also represent themselves, appearing pro se, pro per, or in propria persona. The process is overseen by trial judges. They review filings, issue interim orders, and, when necessary, preside over trials to resolve factual disputes. The trial court proceedings and decisions are reviewed for legal error by appellate judges or justices. In a complex modern society, judges would be overwhelmed if plaintiffs could simply walk into court and orally present their grievances. To prevent this, legislatures and courts have created detailed rules of civil procedure that govern every stage of litigation, from filing the complaint to final judgment. These procedural rules are distinct from substantive law, the rules defining rights and duties, such as contract or tort law. While people often assume substantive law alone determines the outcome of litigation, procedural rules profoundly affect whether a plaintiff can even reach trial, let alone prevail. They also make litigation expensive and time-consuming. Most people have some familiarity with basic substantive law, ownership, promises, accidents, but very little understanding of procedural rules. What knowledge they do have is frequently distorted by dramatized portrayals in movies and television. Even many newly licensed California attorneys find the state's civil procedure rules challenging. Although these rules form the backbone of daily practice for most California lawyers, 3 years of law school, which typically emphasizes the federal rules of civil procedure, rarely dispels their complexity. The purpose of this video series is therefore straightforward: to explain the fundamental concepts and principles of California civil procedure, distinct from federal procedure, in a clear, step-by-step, chronological manner. Final reminder: the contents of this video are for educational and informational purposes only. They do not constitute legal advice and are not a substitute for personalized guidance from a licensed attorney, familiar with your specific facts and circumstances. No attorney-client relationship is formed by watching, liking, commenting, subscribing, or communicating through this channel. Laws change over time and vary by jurisdiction. Do not act or refrain from acting based on anything in this video. Seek advice from a qualified professional in your jurisdiction. The creator disclaims any liability for loss or damage claimed to result from reliance on this material.